The most common kind of discretionary trust with standards is the support trust. The trustee is to distribute assets from the trust as needed for the support of the beneficiaries. Support is interpreted to mean to maintain his standard of living. It is an objective criterion in that his accustomed standard of living requires the trustee to make distributions within a certain range, and it requires discretion in that in the course of his life, a beneficiary will have different needs depending on his health, inflation, life crises, the birth of children, marriage, divorce, children's health needs, and so on. A trust with a standard of comfortable support and happiness, or some broader standard than support, gives the trustee permission to pay out more to the beneficiary, so not to be limited by the standards to which he has become accustomed. The next generation of beneficiaries, probably the settler's children, cannot take the trustee to court for being too generous, so long as the assets are being used for the beneficiary's lifestyle and not in a way that is wasteful. Now, when we get to the creditor's ability to reach trust funds, we find that, surprise, surprise, their power mirrors that of the beneficiary. If the beneficiary can reach it, the creditors can reach it. This makes sense. It's the beneficiary's property in the sense that he has a right to it, but if the beneficiary cannot compel the trustee to hand over certain property, neither can the creditor compel the trustee. So we get this result that traditional suppliers of necessities, food, medicine, and shelter, and claimants for spousal and child support can recover their costs from a support trust. The theory here is the creditor's rights, again, correspond to the beneficiary's rights to necessities. The beneficiary's rights to support include an increased payout to care for spouse and children, and that's it when it comes to recourse against a support trust. I don't expect you to know the restatement or the UTC in particular. Only certain creditors have rights in a support trust or against a support trust. Remember that the beneficiary can compel the trustee to act, but he cannot sell his interest. However, traditionally, certain creditors can get reimbursement from the trust, the theory being either that if the beneficiary can demand distribution for necessities, then providers of necessities can demand payment for the trust, or, here's an alternative theory, the settler wanted the beneficiary not to starve. In that case, he would want providers to furnish goods on credit, secure in the knowledge that they would get their money. Also, the beneficiary's spouse and children may enforce claims for alimony and child support against a support trust. But no one else can reach the trust. And there's a really nice example of that on pages 699 to 700. Stephen was the beneficiary of a support trust. Stephen tried to kill his brother Richard. Richard won a judgment against Stephen for attempted murder. Stephen does not have enough assets of his own to pay the judgment. Can Richard reach the trust? Stephen is in prison, and his support needs are being met by the federal government or whoever runs the prison. So the answer is no. Richard cannot reach the trust. The court cannot compel the trustee to make any payment to Richard, and that's the traditional view. Creditors cannot reach the beneficiary's interest in a support trust. So it's a strange idea that a beneficiary does have a property right in the trust property, and that he can compel the trustee to distribute as much as is necessary to maintain the standard of living, but she or he has no property right that creditors other than suppliers of necessity can reach. So this is not intuitive. We're moving towards a more unified law for creditors' rights. On page 701, a new uniform trust code rule. tries to collapse all of these categories, or at least to design a new standard that will apply to all kinds of trusts, but this is speculative at this point, and I don't cover it. Well, when can the beneficiary get a court order to enforce his rights in the trust? Ordinarily, I would ask you this in class, but here I merely present it. In a mandatory trust, where the trustee has no discretion, pay all the income, then the standard is very clear and the beneficiary can sue if the trustee doesn't make the required payment. If it's a discretionary trust with standards, like a support trust, then the beneficiary can sue if the trustee's application of the standards is not reasonable. If it's a pure discretionary trust and the trustee has complete discretion, then the beneficiary can sue if the trustee does not act reasonably and in the spirit of the trust. And as to spendthrift provisions, we're getting to those right away. A spendthrift trust is not really a separate thing. It's any trust with a spendthrift provision. A spendthrift is someone who wastes or squanders money. So the settlor wants to provide his beneficiary a guaranteed income or whatever support, but does not want him to blow his assets in advance. The fear is that the spendthrift will try to gamble away or sell his next month's installment or even the whole income stream. The spendthrift provision is a blunt instrument. It's just a decree that the beneficiary cannot sell or promise to give away distributions from the trust before they are made. That decree is called a spendthrift provision or a disabling restraint. Here's an example. No interest of my son James in income or principal shall be anticipated, encumbered, or assigned. No such interest shall be subject to the claims of his creditors, spouse, divorced spouse, or others. If the beneficiary does promise that his debt will be paid from the trust distributions, his promise is unenforceable. The only way a creditor can get his money is by waiting until the trustee pays the beneficiary and then grabbing him, or more likely, waiting until it's paid into his bank account and then getting a lien on the bank account. The creditor cannot compel the trustee to pay him. So there are various theories about why this is acceptable. One is that the creditor should have been more careful. MasterCard shouldn't extend $10,000 worth of credit to a man just because he's wearing a tuxedo. Another principle that makes it palatable in American law is that the trust is considered to be the donor's property. And the idea is, I don't trust my kid with money during my lifetime. I didn't pay him money if that would go straight to a creditor. I can do the same after his death. It's still my money after his death. I don't owe anything to my son's creditors. So the court recognizes this extension of the donor's power to give or withhold money way beyond his death. So dead people have rights too, you know, and that's one of my, I'm a big fan of dead people, as you know. States go different ways on one particular group of creditors, and that's child support or alimony. So the majority say a spendthrift trust will not bar a claim for child support or alimony. A child, a spouse, child support, alimony, those individuals can demand compensation from the trust. A minority say that a spendthrift provision does bar claims to an ex-spouse and children. So talk about, you know, creditors being shortchanged. Here are some standard exceptions to the restraints on alienation. They're not uniform. Some states are more protective of spendthrift trusts and some aren't. So spouse and children, as we just saw, in most states they can reach a spendthrift trust. That is, they can get a court order that the trustee should pay them. Creditors who furnish necessities, we saw that they always have recourse against a support trust. In most states, they also have recourse against a spendthrift trust. The government, including Medicaid, can reach spendthrift trusts, now this is a federal rule, so it trumps the states, we'll see that Medicaid has a special status in the next class. So the in-class portion for the weekend students and the following day class for the day students. The IRS can also pierce a spendthrift trust, so you can't hide from the IRS. In almost all states, all creditors of any kind, can reach a self-settled trust. So if the donor puts his own property in trust of which he is the beneficiary, so he maintains the use of his property, he doesn't give it away, then creditors can reach that. But there are some states, a number, maybe 10, I guess, that have rules to protect these trusts as well, so that under certain circumstances, creditors cannot reach even the donor/beneficiary's interest in the trust. Well, this is a very uninformative slide. I'm including it just to talk over. The Scheffel v. Kruger case is horrible. Kruger was the beneficiary of a trust set up by his grandmother in 1985. It has a spendthrift provision, which is on page 699 at the top, a block quotation. The creditor is a certain Corey, who at the age of 2 was the victim of a sexual assault, in fact 80 separate counts of sexual assault, by Kruger. Kruger videotaped these assaults and posted them on the internet. Kruger was convicted in criminal court of these 80 counts of aggravated felonious sexual assault. He did appeal the criminal conviction, you might like to know, on the grounds that they all occurred in a 25-minute period and that such a brief event shouldn't give grounds for 80 separate counts of sexual assault. The appellate court sort of agreed, but did not overturn the lower court. Anyway, little Corey was awarded $551,000 in damages as a default judgment. So keep that in your mind, default judgment. Kruger's own assets didn't stretch that far, but he was the beneficiary of his grandmother's trust. The court holds that a restraint on alienation is good against tort creditors. The court was unwilling to overturn the statute. States are indeed split on this question of tort creditors. Some say that a tort creditor differs from other creditors, and spendthrift clauses shouldn't apply to them because they're involuntary creditors. So we argued that MasterCard should check before it gives someone a $10,000 credit line. Here, Kruger's victim obviously could not check. Here he was a child, in fact. He was the victim of a crime. He didn't have any opportunity to exercise his judgment. The only real argument in favor of this kind of holding, that tort creditors shouldn't have access to a trust with a spendthrift provision, is that it is Kruger's grandmother's trust. Since tort creditors would not have any claim of action, sorry about that, can't turn that on, wouldn't have any claim of action against Kruger during his grandmother's life, so they should not have a claim in death. So somehow, I don't think this is what grandmother had in mind, but that leaves us with this holding. And what would you say is the lesson from this case? Well, from an article on estate planning, the author said, although the result in Scheffel was perhaps morally unfortunate, it does emphasize the asset protection planning opportunities available through the use of a spendthrift trust. So the lesson is good news for us trust preparers.